This is Colin O'Keefe for LXBN TV. Yahoo CEO Marissa Meyer, hot off the heels of her controversial remote working policy, has now instituted a new employee-friendly parental leave policy. Joining me today to explain the basics of that policy and some interesting questions it raises related to the Family and Medical Leave Act is Jeff Nowak, attorney with Franczek Radelet and author on the excellent FMLA Insights. Jeff, first, can you explain the specifics of how Yahoo changed up its policy and how it compares to what you normally see from employers?
Sure. Colin, thanks for having me on today, first of all. Earlier this month, Yahoo announced a pretty significant change to its parental leave policy. In effect, it would allow up to 16 weeks of paid maternity leave to female employees and up to 8 paid weeks of paternity leave to its male employees. It's significant in two respects. One, you've already pointed out, Yahoo has been in the news over the past couple of months because of its change in allowing employees from working from home. Secondly, this policy is pretty significant because it's a much more generous policy than we typically see from an American business. The Department of Labor earlier this year issued the results of a survey indicating that about 1/3 of American businesses provide some form of paid maternity leave. About 20% of American businesses provide some form of paid paternity leave. So as you can see here, this is pretty significant. Not only does Yahoo have a paid parental leave policy, but it's arguably sweeter than what we see from other companies. And I can't necessarily haggle with the statistics that we're finding from the Department of Labor. I think it's safe to say that a minority of American businesses have at least a formal policy of paid parental leave.
I see. So, and second, on your blog, you raised some questions with regards to the FMLA, the Family and Medical Leave Act. What stands out to you in that regard?
Well, there are a whole host of FMLA issues when it comes to parental leave after the birth of a child or a placement into foster care or adoption. One stands out in particular recently for me because a number of my clients have been grappling with it, and that's the concept of whether employers can require moms coming back from maternity leave to provide a fitness for duty certification. Keep in mind, by its very nature, bonding leave doesn't involve a serious health condition. It's leave under the FMLA for both moms and dads to take time to bond with their children. There isn't a medical condition that's at issue. So under the FMLA, it would be illegal to, as a general rule, to require moms returning to the workplace to provide medical certification that they can, in fact, perform their job. I offer one caveat, however. In those instances where mom is coming back to work after, let's say, 2 weeks after childbirth or 4 weeks after childbirth, now I think we have a different situation. And at least under the ADA, you can require your female employee in that instance coming back from leave quite early after childbirth to confirm with written documentation from her physician that she's able to perform the essential functions of the job. As a general rule, we understand that recovery period after childbirth to be anywhere from 6 to 8 weeks. So if your female employee is returning from maternity leave prior to that period, I think you do have a good argument as an employer that you can require that certification, that documentation from the physician that she can perform the job.
I see. So lastly, one last question on this. You referenced in your first answer that the difference in leave time for parents differs from males and females. Does this stand as an example of gender discrimination, or is this generally par from the course for employers and parental leave policies?
I'm glad you raised the issue. I got a lot of feedback on my post on this question. Where a number of employers asked, "Hey Jeff, the 16 weeks that Yahoo is offering moms versus the 8 weeks they're offering dads, is that discrimination? Is that evidence of gender discrimination?" Generally speaking, it's not. Let's work with Yahoo's policy since we're discussing it. Presumably, the 8 weeks that's being offered to dad as well as mom relates to bonding leave, that time that they have with their child. The additional 8 weeks that mom is receiving presumably is due to that recovery period that I just mentioned. And if the rationale is indeed providing that additional time to recover from childbirth, then it would be pretty clear if it's tested in court that policy would stand. It would not be evidence of discrimination. However, if Yahoo or another employer is offering additional leave to mom versus dad, or vice versa, in the case of adoption or foster care, where you don't have recovery from childbirth at issue, now we potentially have a discrimination issue.
Very interesting. It's good to see Yahoo implement such a progressive policy, but it certainly raises some questions with the FMLA. Once again, that was Jeff Nowak of Franczek Radelet. For more of his insight on this story and for really the best publication around on the Family and Medical Leave Act, be sure to visit FMLAinsights.com. And if you don't already know, visit us at LXBN.com for hundreds of these LXBN TV video interviews along with curated commentary from the LexBlog Network's more than 80,000 members. Thanks for joining me today, Jeff.
Thanks for having me, Colin.